PPO to the respondent based on the circumstances? And the respondent's short answer is yes. I would like to reserve 2 minutes for sir rebuttal.
Okay.
I have 3 arguments to make today. First, this court has the power to grant a PPO to the respondent as she is a family member pursuant to Section 64F of the Women's Charter. Secondly, although the parties no longer live together, a PPO is still necessary for her protection. Thirdly, the respondent humbly proposes a narrow rule that governs the granting of PPOs to cohabitants like the respondent. On my first argument, that the respondent is a family member pursuant to Section 64F of the Women's Charter, I have 2 points to make. First, it is clear that the court has the discretion in deciding who can be a family member. The court's discretion is stated twice in Section 64. At the start, where it states unless the context otherwise requires, and in Section 64F, where any other relative of the person who, in the opinion of the court, should, in the circumstances, be regarded as a member of the family of the person. Secondly, Parliament intended for PPOs to protect people suffering from family violence. In the 2012 debate about domestic violence against live-in partners, amongst live-in partners, Mr. Teo Chee Hean explicitly stated that the government does not condone acts of violence regardless of the marital circumstances. PPOs are the most effective way of catering to the sensitivities of family violence. Parliament has recognized that family violence cannot be treated as any other form of violence. As stated by Mr. Abdullah Tarmugi in the 1995 Family Violence Bill debate, the complex emotional mechanics when people bonded closely inflict physical or psychological pain require that special remedies be given to address such a problem.
Don't you have to establish that she's a family member first before we talk about family violence? If not, all these things that you're quoting would be out of context.
Yes, Your Honour. Okay, but applying these considerations to our circumstances, the respondent should be considered a family member because she falls squarely within the class of people that...
What is so unique about the family circumstance that this entire section on family violence has been enacted and is restricted and protected for these persons? What is so unique about family violence as opposed to other sorts of violence in the street?
Okay, Your Honour, family violence, as stated in the Parliament, involves people who have been in loving relationships who inflict physical violence upon each other. This can be distinguished from a stranger inflicting violence on another stranger, where they can just break off all ties and seek harsh remedies, such as in the criminal law or tort law. However, practical constraints restrict these family members from seeking such harsh remedies. For instance, in our case, the respondent cannot seek recourse in the criminal law because she's dependent on the appellant to take care of the child. Moreover, it would be pointless to pursue an action in tort law because she's not seeking for compensation. She's only seeking for protection, which is what a PPO would give her.
2 things concerned. In tort law, you can also seek an injunction. And secondly, don't you think actually a PPO is also a very harsh punishment? I mean, you're now saying that, look, stay away from me, I don't want you near me, I don't want to see you anymore. To me, isn't that very harsh as well? Telling a family member that.
Okay, with respect to your first question about seeking an injunction, it is true that the respondent could have brought an action in the tort of harassment. However, the requirements there are different. There are different requirements to establish, and
Such as what requirements do you happen to know?
I don't have it with me exactly at hand, but one of them is that the harassment must be of a sufficiently repetitive nature, and as for the protection of family, which provides for harassment, the threshold is much lower because the harassment just has to be caused with an intent to cause or knowing that it is likely to cause anguish to a family member. Thus, this remedy is faster and easier for family members to
So you're saying that in the harassment suit, your client may not be able to achieve the injunction, but in a PPO situation, the requirements are fulfilled. At least the requirements of necessity and family violence.
Yes, Your Honour, and also because a PPO would be, the remedy of a PPO would be presumably attained faster than a remedy of an injunction under harassment.
In practical terms, not necessarily true, but I take your point.
Okay. And with respect to your Honour's second concern about a PPO being a harsh remedy, the respondent submits that this remedy may seem harsh, but it is imperative that the person suffering family violence gets the protection that she needs. And it is relatively less harsh than, for instance, having to pay a hefty fine or serving a jail term. Okay. So based on the circumstances of this case, it is undisputed that the respondent and appellant were strongly committed to each other in a genuine relationship. This can be seen from them living together for more than 8 years, their financial interdependence, and intention to start a family. Thus,
Counsel, before we go into all that, is the respondent even a relative? Because I think she needs to fulfill herself as a relative first before the judge we can consider whether before we can exercise our discretion. So does she even, what is a relative, and does she even classify as a relative?
okay, the Women's Charter defines relative as relative includes a person who is related through marriage or adoption. While, however, as the trial judge pointed out, the word includes evinces an intention to leave this category of family members open and to the discretion of the court.
Open but not so open that it can include anyone, which is why there are the circumscribing words of a person who is related through marriage or adoption, right? Which neither of which your client falls into. You want to address that point? Because I agree with you that includes suggests the categories are not closed, but at the same time the categories are not so wide that they can go beyond, it appears, marriage or adoption. So how would you respond to that?
Your Honour, the respondent submits that the classifications of marriage or adoption are only meant to be illustrative and not exhaustive in themselves. Parliament has clearly Parliament clearly does not condone family violence, and as stated in the Court of Appeal case of Chin Xiao Noi, the word includes in itself makes a definition extensive. Even though it could be said that Section F should be considered in relation to sections A to E, the respondent submits that this should not be the case because if you giving the court discretion to decide whether a person should be a family member based on the circumstances, and yet tying the court to these restrictions of marriage or adoption will render this discretion artificial.
I see what you mean. Alright.
Okay, if I may move on to my next point, although the parties no longer live together, a PPO is still necessary for the respondent's protection. I have one point to make here, and that is that necessity turns on the evidence as a whole. This was established in the case of Li Wei-Jin and Low Chi-Chin, when the court further elaborated that contact between the parties is but one factor. Furthermore, Section 64's inclusion of continual harassment in the definition of family violence indicates that necessity does not turn on physical proximity alone, and the court will consider the entirety of the circumstances to determine necessity.
Has the harassment in the act been defined? Meaning, does it have to be physical harassment? Does it have to be electronic?
No, Your Honour. It was given a very wide definition, and it just has to be committed knowing that it is likely to
But
cause
has any
anguish.
court ever tried to define what harassment means within the context of this section?
I believe not, Your Honour.
Okay.
Okay. Applying this to our circumstances, Your Honour, I see that my time is running out. May I quickly wrap up?
Yeah, sure.
Okay. Based on a holistic examination of the evidence, a PPO is necessary for the respondent's protection. The vengeful voice messages that the appellant has sent must be taken in consideration of his evident propensity towards violence and his volatile temper. Further considering his irrepressible anger towards the respondent for the harm that she has caused the child, the appellant could be likened to a ticking time bomb that no one knows when will explode. Furthermore, the psychiatric report has indicated that the respondent is currently suffering anxiety that no amount of counselling or medication can eradicate. Therefore, the respondent requires a PPO not just for her physical safety but also for her fragile mental health.
I see. Okay.
Okay, and because of this, has my time run out? Okay.
we wanted to.
No, because okay, I'll quickly touch on my narrow rule then.
Oh, your time has run out.
Okay, since my time has run out, I humbly request that this court rule in favor of the respondent.
Okay.